I think that the Supreme Court has spoken emphatically that the decision of the Tamale High Court was made without jurisdiction, and so the court has quashed it and is hereby quashed. So Honorable Nyindam still remains the MP of the people of Kpandai. So we call it still maintained.
To thank my lawyers and also use this opportunity to thank the Supreme Court judges for the ruling, because it's clear that the people wanted to change the will of the people of Kpandai, but the Supreme Court has affirmed the will of the people, and I'm most grateful to them. I also want to thank the party from the head to the bottom, that is national, regional, and the constituency, for the support they've given me. And the people of Kpandai, I'm sure that when you are in Kpandai today, you will see the joy of the people.
Now, as a party, we are aggrieved by this decision, and therefore we will advise our candidate in the matter regarding the next step to take. But the court is a court of equity and of law. We should be interested in the Gazette notification published by the Assembly Press under the authority of the Electoral Commission that was brought to Parliament, for which people like me were sworn in. That cannot be a gazette that will be discounted by the court, because it's a public document. The NPP cannot benefit from that gazette notification and come to court and say that that is not the proper document.
Right. So you heard Gary Nimakomafo, who led the NPP legal team. One of the members of that team is here in the studio to the Supreme Court with a certiorari application seeking to quash, and actually got the Supreme Court to quash, completely annul what the High Court in Tamale did. And you also heard Roxanne Nelson Dafiamapo, Eche Kwame Dafiamapo, right? He also is in Parliament. He is the Majority Chief Whip, and suggesting, he actually said that they may want to consider the opportunity of a review to the Supreme Court to review this decision. Some say that one, he should forget it because it won't work, because 4-1, if 2 judges are added, it won't change anything. And it's most unlikely that you get any of the 4 judges who held for Yindam change their mind in the next, if a review was mounted. So here in the studio, Fatima to Abubakar, who is former Minister for Information and spokesperson to His Excellency Nana Addo Dankwa Akufo-Addo. Dr. John Osai Kwapong is Democracy and Development Fellow of CDD Ghana and Project Director, the Democracy Project. Kwame Boafo Akufo, Esquire of Ekropong Ekwapim, also joins us. Kwabena Abankwayeboa is Vice Chairman of the NPP and Presidential Elections Committee member, right? He is former National Treasurer of the NPP as well. Sofo Tanko Rashid Computer, the man we spoke about a while ago, who said that they are going to be conducting a parallel, checking of the NPP's results. And I said he's such a provocateur. He's right here. He's Deputy National Director of Elections of the NDC, of Elections and IT. And he's also the CEO of GIFEX, that's the Ghana Investment Fund for Electronic Communications. Joining us from his base in the United States of America is the surgeon, Dr. Arthur Kobina Kennedy, physician and political activist. Thank you, ladies and gentlemen, for making time to join us.
Thank you very much.
Thank you.
Right. Because you have to go and vote, This is an important vote for you. Let's begin and see if we can make time for you to be able to go and vote. So this is the outcome of what happened. The NPP has been happy, and people are questioning the NPP's integrity, that when the court held otherwise, you took the judge to the cleaners, particularly Osahe Alex Markin. But now you are happy. You are singing that they have done well.
Anyway, Samson, good morning to you. Good morning to your distinguished panelists who are with us in studio and virtually, those who've joined us virtually this morning, and also to your cherished viewers at home. First of all, the NPP's track record really is the fact that we believe in the courts, and we, at least in our most recent dispensation, starting from when we sent the very first historic presidential election petition to court in 2013, you would realize that, if you would recall, that His Excellency, the former President of the Republic, Nana Addo Dankwa Akufo-Addo, set a precedent. The world was so proud that the petition that the President sent, the evidence that was adduced, the statements, or what the cross-examination of His Excellency Dr. Mahmoud Bawumia at the time, we were so confident, based on the records on our pink sheets, that we had won the election. But to the admiration of many, when the court brought the judgment, and the judgment was not favorable to us, the grace that was shown by His Excellency Nana Addo Dankwa Akufo-Addo, even in the face of disappointment, was admirable. We have always followed that footstep and track record. Of course, the story was different during our time when His Excellency Nana Addo became president. The NDC was always up in arms, calling their lordships every name under the sun but the children of God.
Unanimous
they
FC.
Called them Unanimous FC. They said the courts were packed with NPP judges, and they needed an opportunity to come and reset the courts and to balance the court. I don't know what that balancing act meant.
But recently, I think Markin did worse.
So it cannot be compared to that, in all honesty. Respectfully, if there is anything following that, probably it is some of the character traits that some of our people have learned from the NDC. But it is not a generic posture of the New Patriotic Party as I know it. We are lawyers when we go to court, just as the farmer goes to the farm and the trader to the market. Our workplace and our business place is the court. So at no point in time would I disrespect or put out certain words that will bring the reputation of the court.
We're talking about your party as represented by the minority that had a press conference and use unspoken words.
I am saying that was an exception. The judge and the judiciary. I am saying that was an exception to the rule. And if you have followed how NPP treats the courts, that has not been the general rule. I haven't done that. I've been going to court with Gary. Even in when we went to Tamale to move the application for stay, if you follow the proceedings, if you have the record of proceedings, you would realize that we're not even blaming the judge. We said that if the issue of the dates, the facts of the dates of filing the originating petition was brought to His Lordship's attention, we were confident that he would not have entertained the matter in the first place. So hold on, I'm coming to you, get into the substance, but I just want to get a feel around the table. Yes, Prof, what do you say? Did you expect that this was the likely outcome? The EC had already, started the plans for the rerun.
So, good morning to the co-panelists. Good morning to the viewers.
And I realize you're taking an interest in the judiciary yourself, in the Afrobarometer work.
Yes. So I didn't expect that outcome, but I would also say that I was pleased with that outcome, in the sense that if I go back and look at how we've handled disputes about the outcome of a parliamentary election. There were two cases that immediately came to mind. I think it was the 2004 election, I think it was Akwetia, where there was some violent incidences in a number of polling stations leading to contestation about who was the rightful winner of that election. And the remedy by the court was, okay, just go back to those polling stations where there were issues and then rerun them.
Right.
And then I also thought of the situation with Ablekuma North, which was, let's go back to the problematic polling stations and rerun them. If you also go back to the Supreme Court decision in the 2012 petition,
right,
the minority opinion said, look, if there are some infractions as part of an election, separate them into two, administrative errors and legal infractions. If there are legal infractions, then your remedy is where those legal infractions or errors occurred, then you go there and you fix it.
Not the entire.
So when I looked at the Kpandai ruling, I was quite surprised that if you look at the facts of the case, I mean, there was no dispute about the fact that certain polling stations and their results were problematic. So I was not sure why the judge's remedy then was throw the whole thing out and have a do-over, as opposed to let's just remedy the problematic areas.
Nonetheless, did you find the reaction, particularly from the minority group, reprehensible? Now, the Afenyomakin also issues a statement and says, this is a victory for the rule of law and for democracy. Some of the judges that they seem to have made adverse comments against them, particularly about Justice Georgina Wood's, Gertrude Tokonu's removal, are in this suit as well and held for their candidate. I'm talking about Justice Amadou Umoro Tanko, for example. So those who held the four who held in favor of the quashing the decision of the High Court, Justices Amadou Tanko, Yoni Kolendi, Samuel Kwame Adibu Esiedu. Does that name ring a bell to anybody? And then Henry Kofi. It was Justice Gabriel Scott Poorman who dissented.
You know, partisans tend to have this love-hate relationship with institutions, right? When the outcome of institutional decisions favor them, they tend to be very happy with the institution. And typically when it doesn't favor them, then they tend to, have issues with the institution. So if you look at historically how they've responded to court rulings or even other kinds of institutional decisions, the institution is great if their pronouncement is in line with their expectations or what they want. And in fact, you also see that reflected in how citizens respond to the question of trust in institutions in the Afrobarometer survey. I always say that when a citizen's party is in power, the party they say they feel close to is in power, you see their level of trust go up a little bit more than when the party they prefer is in opposition.
So what you may find their unprincipled conduct eventually affects the perception of the
precisely
person about the judiciary.
Exactly. You see that reflected in various rounds of the survey where trust keeps changing depending on whether your preferred party is in power or not, to the point where even in one of our Afrobarometer surveys, there's even a high perception that Ghanaians believe judges tend to be very influenced by politics than just looking at the law in their decisions.
All right. Yes, so what do you say?
Well, let me say good morning to you and then my co-panelists and the cherished viewers across the globe. Council, we accept the decision of the Supreme Court. We are a law-abiding political party, but we disagree with the ruling. We disagree with the ruling totally. Total disagree. And we are waiting for the reasoning behind of their ruling on the 6th of February. They indicated it to come out on the 6th of February. Then we advise ourselves appropriately. Because if you look at, let's set the business straightforward. The Supreme Court doesn't have jurisdiction over the substance of the matter. If you look at the Enabling Act, the PNDC law 284, that talks of election petition. Under Article 99(1) of the Constitution, it is only the High Court that goes into election petition matter. Supreme Court doesn't deal with that.
Supreme Court is a supervisor of the realm.
But it doesn't go into
if something goes to the High Court or any other court, the Supreme Court has power to review it.
We agreed. But we are saying that when it comes to the substance of the matter, going to the nitty-gritty of election petition, under Article 99(1), it is the High Court. That one there I defer that one to you. Now, when you look at the matter critically, what the Supreme Court did was based on technical issue of gazette, not the substance in itself. If you go and look at the ruling of the High Court, page 151, it's very clear that the election was properly rigged. The judge makes references to those things. And I have the ruling, I can make it available for you, for them to tease out that portion where the judge, the learned judge, mention of a polling station recording 1,422 votes. Council, you know that we don't have a polling station like that in Ghana. That has a voter population of 2,000. The highest we have is 750. 750. If you have more than 750, it will split into two. But this is a kind of voting that occurred in Kpandai constituency. Now, why are we battling the issue with Gazette? And that is
so for the Gazette, you mentioned the matter of, is it overvoting?
That is what is pointing at.
Okay, that there is a polling station.
A polling station.
Which has less than 1,000, but there was recorded over 1,000 votes.
1,000, yes.
That's, what do you make of what Dr. Osankwaphong says? In that case, hold that the elections have been, damaged in this particular place. So go and correct it, rather than say go and do a whole new election.
That was not the only one. Don't forget, Honorable Nyendam won about 3,000 votes. In two polling stations, another polling station reported 1,200 votes. So that means in two polling stations, he has scored almost 2,000 votes. So what are you talking about?
So impeach those two.
So we are saying that is why the judge was looking at it. And we said that when we sent our reliefs to the High Court, we sent 14 reliefs. And then at the case management, this 14 was consolidated, set out for trial. 3 issues were set down for trial. And one of them was we were asking for the nullification of the entire results because of the infraction of Regulation 37 and 39 of CI 127 by the electoral officer and the presiding officer, the returning officer of the constituency. We gave copious evidence and tendered evidence to show that they violated these enabling 2 regulations of the CI 127. And we convinced the judge to believe that, yes, they didn't do the right thing. They violated those 2 regulations. And those 2 regulations borders on the collation of results of parliamentary election. And it was very clear about it. And so when we did all this cross-examination with them in order to, the ruling came out on 24th November. And it was very clear. I am not surprised my colleagues' opponents ran to the Supreme Court because they know if they had gone through the process of appeal, going to appeal court, they were going to suffer another defeat over there. Because I don't know what kind of new evidence they were going to adduce based on what we had cross-examined them and the electoral officer. So they decided to go on this tangent, of which we are saying we will go into it. And when we filed our affidavit in opposition to their application at the Supreme Court, we're citing them for fraud, the 2 of them. And I'll give you the elements of fraud that we are going to pursue on that.
In your main petition in the Tamale High Court, you were clear about a particular number of polling stations that have been affected, correct?
I said we have set out 14.
I understand
and one of the lists was what we are talking about.
I understand that.
About the number of polling stations.
How many of them?
We had set out about 51 of them.
41.
No, 41 of them, the polling stations.
Right.
Indicating that they should look at this 41 because we're making reference to the regulation 37 and 39 of
the judge was faulted by many members of the public, including some lawyers, that what was before you was to determine 41 polling stations where the voting was allegedly rigged.
Counsel,
so why do you come to a conclusion by saying that let's go have a rerun, I've annulled the whole thing, go have a rerun in the whole constituency?
Counsel, at case management, these 14 reliefs, when we consolidated it into the 3 issues set down for trial, one of the reliefs among the 3 was the nullification of the entire results of the 152 based on the infractions therein. So it wasn't that we're asking the judge to look at only the 41, but we're asking for the judge, which is the 3rd issues set down for trial. The last one, in fact, I wanted to read that one, the 3 issues for trial.
All right.
And the last one was...
You're going to the merits already.
Yes, and that's why we're saying. So it wasn't only that we were going in for only the 41, but we were also asking the judge to nullify the entire thing because it violating regulation 37 and 39 of CI 127.
Yeah, right. There was a relief like that.
On that.
Now let me go to Dr. Arthur Kennedy. Just, brief preliminary commentary on the decision of the Supreme Court, particularly also looking at the posture of the politicians and their commentaries when decisions don't go in their favor. Some of the judges, they actually pinpoint them, name them, and try to, as it were, pit them against the public. So as you can see, I had mentioned in the removal process, some of the judges sitting in the removal process, at least one is here. And then the removal process, the issues that have gone to court. Some of the judges who have also, dismissed some applications by, in the process are also here. And somehow, all those people have held for the Matunyindam. Of course, with the exception of Justice Puaman, who dissents. And we should get to know his reasons why he dissents.
Good morning to your distinguished panel and to all your viewers. I think that this case, it is not the details that matter with respect to my learned colleagues, even though I'm not a lawyer, I'll call them that. I think that it is the broader context. And Dr. Sekwapon begins to tease out some of them. I mean, these Afrobarometer surveys and the mistrust of the courts and others didn't occur in a vacuum. And it is not just the courts. There is a perception that our institutions, including the police and others, are very political, and that when you are in power, it seems that a lot more things seem to go your way. I think that what happened, the thing that gladdens my heart is that it is a victory for the courts, to the extent that the NDC said there is a need to rebalance the courts or reset the posture of the court. I think this shows that maybe tentatively we are heading in the right direction, because since in the history,
but the judges who sat on this, who was appointed by the current regime, I need to check again. They are all from the Akufo-Addo appointments.
Yeah, my point though is that that is why I say we should say that cautiously, because this decision in effect telegraphs the independence of the courts, contrary to the anxieties that a lot of people expressed. Of course, politicians are opportunistic, that when things don't go their way, they call the court names. When things go their way, then they praise the courts. But to be fair to them, the history of our courts have not been good in terms of electioneering ruling, that almost invariably those in power tend to get more favorable ruling. So the doubts that people have, the doubts that the public has some grounding. And even and we can go all the way back, but I don't think we have time. Even in the Fourth Republic, remember the Amo case, 1996 to 2000, when Amo lost a case, I think that Ayawa Sowogon or something like that, and took it to court, and the case took 4 years, and then just before the term ended, the court came back to say that he had won. I mean, such things are blatantly political, and not only that, which is why I said this is not just about the courts. If you recall, there were a number of constituencies that were in dispute just after this election, and there was the question of whether the police could provide security for the counting and other things. It may have been that the excuses were genuine, but a lot of people saw through it and were suspecting that maybe the political winds were beginning to blow in the ranks of the police. So I think that this decision, I think the details are being argued there by the lawyers very well. But I think to Dr. Osai-Kwapon's point, the anxieties of the public and their mistrust have grounded, and particularly if the NPP people are going to be honest, when you look at the kind of things that happened in the last 8 years and how the Supreme Court seemed to respond to certain people's concerns with alacrity. We empanel cases in the morning and hear things the same day, and then other people's cases languish for months. It is very difficult to look at those things and not be convinced that there might have been some element of bias. But I think we should praise the court that what has happened is a good augury for the future, and I hope that it can continue for the sake of the independence of our judiciary and its reputation.
Thank you very much. So I return to Fatih and the question about the substance of what was before the court and the court's decision. Why do you think that the court could not have taken any other decision apart from this one?
Okay, thank you, Samson. When we filed a motion invoking the supervisory jurisdiction of the Supreme Court for an order of certiorari to quash the judgment delivered by His Lordship Justice Batland, I had no doubt in my mind that this action will succeed because it ought to succeed. My brother was talking about the jurisdiction of the Supreme Court, that the Supreme Court does not have jurisdiction over the substantive matter, and that we were trying to find some ways and means to use technicalities to reach the Supreme Court. So
this is in fact a technical victory. It's a legal technical victory.
So I am coming to that, but the context in which he made that comment, I just wanted to clarify that your remedy only lies in appeal from the High Court to the Court of Appeal. When the High Court's jurisdiction is properly invoked, if the High Court's jurisdiction was not properly invoked...
Just hold on one second. I want to listen to Dr. Educhum, who has just voted.
Okay.
Suspected. And today history has been made at Bosomtwe. This is the first time a presidential aspirant, a flag bearer aspirant, has voted in this constituency. So it's a historic moment for us, and I'm excited that this day has come. I'm looking forward to good news in the afternoon. But I just want you to know that I'm very appreciative of the work that has been done by the leaders of this constituency, rallying around me to campaign for me, to do whatever it takes to ensure that we end at the finish line with pride. So we are ending with pride. I'm happy that I'm here today. Tell people that when I was growing up, if somebody had told me that one day you run for the flag bearership of a major party, the New Patriotic Party, even if the person was a prophet, I would have said, no, not me. But today I'm here. Divine providence.
Coming in, you saw the mood of the delegates, the kind of appellations they were showering on you. What came to mind?
What came to mind is that even though Sir John has admonished us to fear delegates, I can connect with these delegates. They are my own, and I've served them well, and I hope they will also reciprocate by saying, we thank you for your service to our constituency, and as you aspire to move up, I want to support you.
And have you heard of any situation in any constituency that you are not happy about? So far, is the process smooth for you in the pressing generally after going through same?
None of my reps anywhere in this country has reported to me that there's something untoward. So far, so good. And I hope it continues that way.
Doc, jokingly, who did you vote for?
I voted for Dr. Yao Osei Educhum, son of the land of Bosomchi.
And is Dr. Osei Yao Educhum winning by the close of polls today?
By the grace of God. Everything is in the hands of God. I've done what human beings can do. The rest is left to divine providence and to the grace of God.
All right, so all the, those who are doing the polls, those who are giving the prophecies, you didn't see that he will win, right? He's going to win, according to him. Yes, so let's get back to Kpandai. And you were talking about the jurisdictional question that Sofo Rashid raised.
Yes, absolutely. He was saying that the Supreme Court does not have jurisdiction on the substantive matter, and that we use technicalities to go to the Supreme Court to get a favorable judgment.
And that's
if we were confident, why didn't we follow the substantive matter and go through the appellate process, of which the Court of Appeal actually has a jurisdiction when it comes, the final appellate jurisdiction when it comes to parliamentary election petitions. I am saying that based on the facts, we could not have properly invoked the appellate jurisdiction when the High Court did not have jurisdiction. The appellate jurisdiction of the Court of Appeal would only arise when the High Court's jurisdiction was properly invoked, and they looked at the substantive matter and subsequently gave a judgment that is not favorable.
But you did both,
as soon as, yes, I'm coming to that.
Both.
Yes, I'm coming to that.
You did an appeal to the Court of Appeal, and then you did a certiorari to the Supreme Court, which you are entitled to do.
That is what I am coming to. The respondent, not the petitioner, the respondent applicants changed solicitors and then brought our law firm into the matter. The moment we came into the matter, that was exactly on 24th November 2025, when the judgment in Tamale was delivered. Of course, what were we going to do? To file a motion, a notice of appeal at Tamale at the High Court, and also an application to stay the execution. But whilst we were investigating, it came to our attention that this particular, the originating petition was filed on January 25th, 2025, which was 32 clear days after the publication of the notification of Gazette. And also realized that the security for costs was paid on 27th January 2025, which was 34 clear days after the publication of the notification of Gazette.
Why are these two important?
This is important because of Section 18 of the Representation of the People's Law, PNDC Law 284. And with your kind permission, let me run, if you would allow me.
Yes, please do.
I will run your audience through Section 18 of PNDC Law 284. And Section 18.1 reads, an election petition shall be presented within 21 days after the date of the publication in the Gazette of the result of the election to which it relates. But a petition questioning an election on an allegation of corrupt practice, and specifically alleging a payment of money or any other award to have been made by the person whose election is questioned, or to have been made on behalf of and to the person's knowledge, may be presented within 21 days after the date of the alleged payment. This is in relation to petitions timelines, but we are interested in the first part, that you ought to gazette, and when the gazette notification is published, you have within 21 days, because this petition was to challenge the declaration by the Electoral Commission. It did not relate to
when the EC makes a declaration,
yes,
and they have not published a gazette,
yes,
you can't go to court.
No.
You have to wait until they publish a gazette.
Absolutely.
And when they publish the gazette, you have within 21 days.
Absolutely.
If you go after 21 days, you are lost.
And that is what I'm coming to.
Right.
If you look at section 18.3 of PNDC law 284, it says 18.3, the time limit provided by this section for the presentation of an election petition shall not be extended.
Good.
This provision is strict. And the Superior Court of Judicature, in their election adjudication manual, the volume 2, it has also interpreted all the provisions in the Act 284 to say that if you fail to file the petition within time, if you fail to pay the security for costs, there is nothing that the courts can do to salvage your case. The NDC's case, the petitioner and his assigns, their case is that indeed they had filed an earlier petition and they were misled by counsel for the respondents that their petition was premature, and it is on that basis that they withdrew. They said they were informed that the Gazette was on 6 January. And it is on that basis that they withdrew that petition and filed this originating petition. But something, I put it to them that that is absolutely false. It is false because their original petition was filed on 23rd December 2024. As at 23rd December, all these Gazette notifications that they are talking about in contention were non-existent. There is no single record of any Gazette notification, not from the EC, not from the NDC, not from the NPP, not from Ghana Publishing Company Limited, shows that as at 23rd December 2024, there was any publication. So if you want to send your case to court and you file it prematurely, it means you have not properly invoked the jurisdiction of the court. And let me also remind you that when they filed in opposition to the application that what they filed was premature, and at the time, the lawyers for the respondent believed that the Gazette was on 6 January. They did not even wait for the trial judge to make a pronouncement, to hear the matter and make a pronouncement on it. They quietly went behind the scenes to withdraw that original petition because they were convinced that it was premature. That being said, if you look at the deposition of Honorable Martin Yindam, their own originating petition, it should all put together, it should tell you that our contention, even when we wanted to appeal, was that the court is not Father Christmas. The court will not set up a case for you that you have not set up for yourself. You cannot just walk into court and ask for any release at all and they will grant it because you have come to ask for it. You have to show cause. And in a parliamentary election where we have 152 polling stations, both the NDC and NPP polling agents endorsed the pink sheets in 150 out of 152 polling stations. And you go to court stating that there were widespread irregularities in 41 polling stations. That's your contention. And my brother has been making reference to 2 polling stations where they were overvoting. But if you look at the total valid vote difference, which Honorable Matthew Yindam won with 3,734 votes, if you take the entire votes in those polling stations that he's been making reference to out, it would still not be sufficient to change the outcome of the elections.
Which is mostly the principle of election petitions, that if what you are challenging for the other party, if they dash all of it to you and it still will not change the results, then the results will not be annulled.
Absolutely. Okay. And the second issue is that they've been saying our client brought an extract to court showing that the Gazette was on 6 January. The majority chief whip, he has also been sitting on TV and showing a Gazette from 6 January, which is a complete book, which is not the extract that they got from the processes that were even filed by our clients. That being said, the contention came out of a genuine confusion that the gazetting was done on either 24 December or say January. But when in another case that we were working on, which is the Republic versus High Court, Koforidia, the NSC Alkumi case,
right.
The ruling that came out was to the effect that the court was convinced that the Gazette was on that the Gazette notification that was published, which includes Akwetia, which also contains a notification for Kpandai, was done on 24 December 2024. So that should have settled the matter. Because if you go to Ghana Publishing today, as the EC has been also reiterating in their defense, that the only Gazette notification you will find on record is what I am holding.
Okay.
And if you open it and you look for Northern
Region... What you are holding is a Gazette dated when?
It contains two provisions.
Okay.
We have... I'm trying to open the Northern Region for you to see where we can find Kpandai.
Okay. You had marked it.
Okay, I had marked it, but it just it fell off. But if you look at the very last page of this Gazette, on page 35, you would realize that the publication relating to that was done on 6th January relates to only 4 constituencies.
Okay. So, in fact, on the 6th of January, there was a Gazette publication.
Absolutely.
But it does not affect Kpandai.
No.
Okay.
Kpandai
which constituency does it affect?
The 4 constituencies that were published on the 6th of January are Dome Kwabenya constituency, Okaikwe Central constituency, Tema Central constituency, and Techiman South constituency.
Okay.
All others were published on 24 December 2024. And this happened because you realize that when we were working on the Ablikuma North constituency case, the Mandamus application, it got to a time they had to consolidate other similar cases that were seeking such release from the court because they wanted the court to compel the EC to complete the collation of the results in some outstanding constituencies. So that is what resulted in this one. But the remaining 272 constituencies, according to the courts, and this Gazette shows that they were all done on 24th. And that used to be the position of the NDC. And that is why they got a favorable pronouncement so far as the gazetting was concerned in the NSC Alkumi case. But because they want to win both ways, all of a sudden they abandoned the 24th position and rushed back to the 6th January position. And I heard their lawyer in court say that, yes, indeed, the notification of Gazette was published on the 24th, but it was re-gazetted on 6th January. I don't know what she meant by re-gazetting, but I am saying that on record, there is nowhere that you will go and conduct a search and get any notification of Gazette contrary to what is contained in this document. It does not exist. So, and we are saying we had to go to the Supreme Court because we were dealing with procedural issues.
So the NDC's candidate filed, that is it Bakpao?
Mr. Ansala Wakpao.
When did he file his petition?
First, 23rd December.
Okay.
And withdrew it and filed again on January 25th.
And filed on 25th of January. And by this Gazette notification, what is your calculation?
It was supposed to be within that 24 to 17 January. There or about 17 January. That would have fallen within the 21-day timeline. But they filed on 25th of January and paid the security for course on 27th. So as a matter of fact, if the courts can say that the facts, nothing else, is that the Gazette notification was published on the 24th of December 2024, there is nothing else to be done.
So they missed the timeline by a day.
About 17 to 25th, that should take us to about 1 week.
1 week?
Yes.
And then
the
also miss the
about
security for course, which you must do around the same time.
Around the same time. And
okay.
There is no extension according to
So from where you sit, the Supreme Court couldn't have done any other thing than to endorse what you put before them.
Absolutely.
To annul the results.
Because jurisdiction goes to the root of every matter.
Right.
Because even if you go to Antenna, they have jurisdiction. There are cases you will file before Antenna and they will say, oh, this one, then let's go to Ahimfie. Okay. It is beyond that. Right, so they say they will not discuss Yausapon because of the weight of the case. How do you expect to go to a competent court of jurisdiction and say the jurisdiction was...
So let's hear from Tanko now. What do you make of this? This is a point you concede and you can't do anything about because the facts are against you.
You see, Counsel, my sister has made our work easier. I told you that we have filed in our affidavit in opposition to the application at the Supreme Court. We're citing them for fraud. The Electoral Commission and the NPP. She has made our work easier. And I'm very happy with her presentation on the element of fraud.
Too late.
Not too late. We are taking that leg. In fact, we are advising our candidate to take that matter up with the CID, to go into the matter of fraud. Look, perjury is a serious matter. They filed on the 6th of January, 2025, a motion with a supplementary affidavit on 21st January. And attach this 6th January Gazette that my sister is trying to run away from. It is the NPP that brought the 6th January Gazette and swore an affidavit that this Gazette was a proper Gazette of the 2024 7th January election. And in that Gazette that they filed at the Tamale High Court, included Kpandai. I have it. I can give all their dissent. In fact, their motion, their supplementary affidavit, and then the exhibit of the 6th January. They did it. They swore an affidavit. And you know, when you swear an affidavit and you lie before a court, it's perjury. And these people are... otherwise, this thing that is happening, Counsel, we have to take it seriously. Because false representation.
When they filed, they didn't ask you guys to withdraw.
No,
you didn't wait for the court to rule and say, in fact, what they filed was accurate. You decided that, oh, what you have seen looks like that's the correct thing. So you withdrew.
You see, when we filed on 23rd, at that time, Electoral Commission was flip-busting. They didn't want to come out. We know we're forcing them because we conducted the election on the 7th. Up to 20th, and you are not gazetting. 21st, there was no gazette. 22nd, there was no gazette. I would say, what is happening to this EC? We have to go to court and force them out from their slumber. So that was the reason why we filed on the 23rd. And so when we filed on the 23rd, quickly, you know that this Electoral Commission, I always describe it as crooked Electoral Commission. Quickly, NPP got hold of a gazette dating 6th January 2025. Where did they get it from? Where did they procure that gazette? That is a question we are going to go in. That is the root cause of the fraud that we are talking of. They fraudulently procured this gazette, attach it to their motion and affidavit, trying to get the judge to dismiss our application.
If you have a document,
yes,
and you believe in that document,
yes,
at the time you had it,
yes,
that will not be fraud.
That is why I'm saying that. But when it turned out that the document was procured fraudulently, that is the element of fraud will arise.
The document that you then relied
on. Because the EC themselves was a party to the matter. The EC was silent about the issue. When we withdrew the matter and filed on 25th, because we believe them.
But the substantive point is that,
yes,
in the end, you concede that you were completely out of time in filing and also paying for security for cost. And the law is plain that there will not be extension if you miss the time. So as the evidence go by the Gazette notification that we have seen, which is the only one available, which the Supreme Court has relied on once and then again the second time, you got it wrong.
No, Council, you see, what happened was this. The 23rd one, of which they came on the 6th January to file. I'm talking of their motion that they filed in dismissal of 2013 was filed on the 6th January. Interestingly enough, the gazette that they used was also on 6th January. So where did they get it? The coincidence was so clear. They filed on
you have canvassed that point.
So I'm saying that, yes, we agreed that our 23rd had a problem, so we withdrew that one. And there was a cost against 7,000, so we had to pay for withdrawing that matter. So when we filed the 25th one, then 27, we paid the cost, the necessary, this is based on Section 18 of
those two instances.
Yes.
Those two instances, you were out of time.
We are not out because we're relying on the 6th January Gazette, which they brought, and the court accepted it, and based on that, we filed. So we're within 19 days. That was our point. But because we based on what they had filed before the court.
Right. So my last question I put to you is based on the Gazette that we are now using. You admit that you got it wrong.
No, you see, we are still not agreeing because that is why we are citing the EC. Why would the EC come out with two gazettes? Because they, according to the NPP, when they brought it, they said they got the gazette from the Electoral Commission.
The EC says there's always been one gazette.
So they must come and answer the question before the CID.
Okay.
Because that one.
So you agree that this Supreme Court panel, they had no option on the basis of these facts to hold the way they held, correct?
That is why we want to wait on the 6th of February to see the reasoning behind it. And then because in open court, lead counsel for the applicant, my good friend Gary Nimako, when he made his submission and sat down, the president of the panel asked him a question on the issue of the fraud. The first interested party raised issue of fraud about that matter. Why is it that he didn't address the court about the issue of the fraud they raised in the affidavit? And I'm happy my sister added to that. He rose up and said it was a genuine mistake. How can this be a mistake? When you make false representation before a court, expecting to get a ruling out of it, and then the ruling went against you subsequently because one went to case management and all that, at the Supreme Court, you now say it's a genuine mistake.
Right.
So that matter must be looked at critically.
Let's proceed, but you would recognize that for the party to say that something was a genuine mistake would negate your attempt to raise fraud. Or quickly, let's hear from you before I go.
Okay, so Samson, as for the CID investigation, probably they should start from the Majority Chief Whip, Honorable Dafia Makpo, because the version of the 6th January Gazette he is also holding. Apart from what he is holding, I have never seen it anywhere before. But the most important issue is that in the case of Abebiu versus Kakari, the court said that estoppel of any form cannot override statutes. So if you know, my brother was trying to dodge whether or not the court only had one option. If it was filed out of time, it was filed out of time. He also admitted that they did not file the first petition because there was a publication of Gazette notification. But because they were impatient, they became frustrated that they waited from 20th, the EC was not publishing.
They did it to compel the EC.
Yes, so they decided to go and file. So if you withdrew such a petition, how can you say the withdrawal was based on some misrepresentation that was made by us? You knew it was premature, we knew it was premature. You were not even going to wait for the court to even make pronouncements on it. And finally, in Ghana, we are in an adversarial system. When you are going to court, I don't go to court expecting my opponent to do my case for me. I don't go to court based on what my opponents will say to me. I go to court on the strength of my own case, my own research, convince myself that I have the proper facts before me. If they had taken the time to do due diligence, to research, to file a search at Ghana Publishing Company Limited, to satisfy themselves that they were filing before time, that would have been the right thing to do.
But
you
the other
cannot
side of the
benefit from
coin,
your indolence.
The other side of the coin is that it may not be a question of indolence and the other things you're raising, that lawyers are supposed to be officers of the court. So there is an obligation on the lawyers to always tell the truth and deal with the facts before the court. So if you are brandishing, a gazette notice, which does not emanate from the EC, they have every right to question it, that something fraudulent was going on.
And I'm saying that because some of the publications were done on the 6th and some were done on the 24th, if genuinely someone was saying that, there is a notification, I have an extract that shows that Gazette was done on the 6th, it can be a genuine mistake. And I am convinced that at no point did our clients intend to mislead the courts. And even
the further proof of that will be that the 6th January Gazette, we can find only 4 constituencies. But as Rashid suggests, in the one that you put in the Tamale High Court, included Kpandai. So how did Kpandai find itself on that one when the 4 did not include Kpandai?
I believe they have also admitted that at some point they were also confused with the amount of information they were getting from interviews, from publication. You ask people for Gazette, someone is showing you one document or the other. The most important thing is that throughout this process, either at the High Court or the Supreme Court, at no point in time have we insisted that with the benefit of hindsight, this is what we insist it is. Because at the time that our clients presented that document, they genuinely believed that that was the case.
And that document was presented in the name of it emanating from the Electoral Commission. And the Electoral Commission now insists that it doesn't have any such document. So do you suspect that there was some sort of fraud that must have happened to have had a Gazette notification to include Kpandai when a Gazette notification, the Gazette notification of 6th does not include Kpandai?
Not at all. If at the time of receiving an information, you believe it to be true, and based on that belief, you go ahead and present it, it is up to the court to also satisfy itself that it has jurisdiction. If the court had investigated and said, no, this document, I have checked with EC and Ghana Publishing, and they said that is not the genuine, they could easily throw it out.
It's not the job of the court to go checking because of the adversarial system.
Yeah. So
if
they should have also checked.
If the court in Tamale also had reliance on that Gazette notification, which apparently included Kpandai, when in fact what has been published at the Assembly Press contains 4 constituencies without Kpandai, then do you really blame the court? Because at the time, the thing you were relying on, the court too had reason to rely on.
I wouldn't blame the courts. And that is why I've insisted that even when we went to move the stay application, we kept saying that if the information as we have it now was within the knowledge of His Lordship at the time of the trial, he wouldn't have entertained the matter. But I am saying that it is not allowed under law for NDC or their candidate to claim that they didn't do any research, they didn't conduct any search, they trusted that their opponent, someone that they were seeking to take a seat from, would go and bring documents to come and support them to prosecute their case. And even when we make mistakes, they will not do the necessary investigation to satisfy themselves that it is the correct one.
Let me go to Dr. Kennedy and return to the studio with Dr. Osai.
Last one, please. In all the documents that they filed in courts, they have only been talking about fraud, no particulars, at no point in time.
That's not allowed by law.
They also believe that it is a genuine mistake, so they cannot even particularize it. They haven't done.
So in our judicial system, anybody who alleges fraud is supposed to give the details of the fraud. We call it particularization, particulars of the fraud. If you file a process and you claim that somebody has conducted themselves fraudulently and you don't provide the basis for it or the details for it, you'll be thrown out. That's what he's referring to. Now, Dr. Kennedy, having listened to the 2 contestants in this matter, what is there some revelation you are catching, and what does that lead you to your commentary on this matter?
Commentary is that it seems that there was fraud at some level. The question is where it occurred. It is possible, as Madam Fatimata says, that indeed they were relying on documents that they believed to be true, but it of course begs the question about where the document they were relying on came from. And given the circumstances, it is possible to go back and find out where it came from. It appears as if it was procured from somebody from the Electoral Commission or from the publishing space. So it should be possible to go back and find out the source of the document.
Or that in this day and age, somebody picked the 6th January Gazette notice containing 4 constituencies, excluding Kpandai, but found a way to impose Kpandai on that one for the purposes of the courts.
Well, that's why I said that there must be fraud somewhere. I think that somebody knew that the question is who knew. But I think that somebody knew that Kpandai didn't belong in that list and that it was put in there. So it is possible to go back and find out how Kpandai got in there. I do not believe Kpandai got into that list spontaneously. So it can be pursued and found. So I think that is a good avenue to pursue, because we need to clean up our electioneering and litigation processes. But listening to them and talking about the jurisdictional issues, election petitions are very complicated. If you remember, in Bush versus Gore in 2000, there was also arguments about jurisdiction. Remember when the Florida Supreme Court ruled, they went to the U.S. Supreme Court, which sent the case back with instructions for certain things to be done. They were not satisfied, so they took the case again. So, and the Supreme Court, in effect, based on the circumstances, we should be careful about saying that it doesn't have jurisdiction in certain cases. But I think that this whole thing is a victory for the courts, and I hope that the very brilliant attorneys that we've seen there on both sides can help the court and the country come to the right decision. And if some bad things were done, then whoever was responsible for that should necessarily be punished, so that we can move on with clear consciences.
All right. Dr. Sakrapo, what will you also say about this? As far as the NDC is concerned, there's another leg that they are not going to give up on. Even if they are giving up on the outcome from the court, which looks like it's almost impossible now, they may pursue a criminal process targeting somebody.
Yeah, I was quite, I found it instructive about this December 24th, January 6th issue of the Gazette, and which one is the quote-unquote real Gazette that either had Kpandai as part of it or not. I'm wondering if, as in the litigation process, was the EC called upon to validate, which one is...
The EC was a party from beginning to the end.
To the end, okay. And did they sort of validate to say, okay, it is the December 24th one that has Kpandai or not? Because ultimately, too, they have a role in ensuring the integrity of our election. So I can see why there will be questions about which one is really the real quote unquote Gazette that had Kpandai on it or not. And hopefully that gets resolved, because ultimately I think it speaks to the heart of our electoral system and the integrity of our electoral system. And we cannot have disputes even around some of the things that ultimately will be needed to even resolve an electoral dispute.
Okay. Interesting comments there. And Frederick Thompson says that the unprincipled conduct of some politicians on the judiciary is worrying, if not hypocritical. The minority party's attack on the High Court judge in the Kpandai case was unwarranted, to say the least. Lawyers are trained in how to challenge decisions when aggrieved, not to publicly attack judges, especially when the remedies of appeal and certiorari are available. Look at their incessant attacks on the Chief Justice, Bafuboni, by the minority. What are we doing to ourselves? I pray we are able to find ways to resolve all electoral disputes within at least 6 months after elections. God help us. Thanks for your message. And we'll be sharing your messages. Let them come in. This is Newsfile. It's your most authoritative news analysis platform. And
Council,
today is the NPP's big day, as they are presently voting across the country. Over 200,000 delegates voting, 211,000 delegates are voting. And then we're expecting that hopefully by 2 p.m. everything would have been done, and we'll get to know whether Bawumia maintains his leadership, as in for the flag bearership, or he will be undone by Ken Ejapon. Yes.
A quick one. We filed particulars of fraud. It is here. I can send them to you.
Okay.
My sister, is here. Look, look at it. It's here. We filed it on. Look at it on 6th January 2025. One way referring to their application and other thing. And so we attached all this in, and that one they were referring to the Republic versus High Court Commercial Division expert, the one that we're dealing with. So we filed particulars of fraud. And that is why we are saying that the issue is not that.
What you are referring to is a certiorari application.
Yes, that's why we are saying that.
Particularized fraud.
No, you know, the way you see the certiorari application, they upload it in the form of judicial review. That's how they
a certiorari is a
of course. So that was the way they've sent it and other thing. We were looking at why would these people did false representation at the Tamil High Court, expecting that they got favorable ruling. It didn't go their way. They abandoned the process of which they applied for the appeal. But you see, something must be clear here. Council, and I'm happy Professor Kwapong made mention of that. The Electoral Commission was a party to this matter.
Yes.
At the case management, the Electoral Commission was seated. They didn't say anything about the 6th January Gazette. When the NPP was flouting all over the place and banding it around, and that thing, the Electoral Commission Council was seated when we were setting down issues for trial.
It's not to be objected to at the case management. It's to be objected to when the cross-examination is going on.
And that is why we say that, look, they filed their written address to the court on the 14th of November 2025. And in their written address, they didn't make any statement about Gazette notification or audited. The Electoral Commission was silent about it.
He who alleges must prove. So if you allege, did you prove it?
Of course. Why do we have to allege? Because the matter traveled on and nobody raised issue about Gazette.
Okay.
And cross-examination and all that. And when they were filing their written address by their
I get your point.
Yes. So,
okay, so let's move on. We need to move on from here. Today is the NPP's big day, and we will continue to bring you our coverage on it. And we'll be, as we continue with these discussions, we'll let you understand what is going on. A while ago, Osei Edichum did vote in his constituency in Jachi Pramso, Jachi. My guests in the studio here are Fatima Abubakar, former Minister of Information, and she speaks for the President Nana Addo Akufo-Addo. Dr. John Osei Kwapong of the CDD is also here. Kwame Boafo Akufo of Ekropong should have joined us on the first issue. He is not online. When we get him, we may hear what he had to say. But if you remember what he had to say when this matter came up first, Kwabena Bankwa will join us, and Sofo Tanko Rashid Computer, Deputy NDC Director of Election and IT, and also CEO of GIFEC is here, and Dr. Kpandai Kennedy, also joining us from the United States of America. Earlier, he has said that he could call us. He called us learned. He said, "My learned friends," and sought to qualify it. Doc, you don't have to qualify it because the professions that are learned, according to history, the law is there, the law profession is there, and physicians are there. So it's a learned profession. Thank you. We'll take a quick break. We'll be right back.